Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Pune ROC Adjudication Order for the violation of Section 203 of the Companies Act. As per this adjudication order, there is the delay in the appointment of the whole-time company secretary, and ROC imposed penalty on the company and officer in default director of 10 lakh rupees in this adjudication order. Let's see the facts of the case. Company having registered office at Pune. In terms of the provision of section 203, subsection 1 of the Companies Act, read with the Rule 8A of the Company Appointment and Remuneration of Managerial Personnel Rules 2014. Every private company which has a paid up share capital of 10 crore rupees or more shall have a whole-time company secretary. As per subsection 4 of section 203, if the office of any whole-time key managerial personnel is vacated, the resulting vacancy shall be filled up by the board within a period of the 6 months from the date of such vacancy. In the instant case, the company has not appointed the company secretary since 7th February 2021 to till date, despite the last appointed company secretary vacating the office on 7th August 2020. Accordingly, the adjudication officer has issued adjudication notice uh, to the company and its officer in default for the violation of the provision of the Act. A reply to the adjudication notice has been received on 18th October 2022 from the company stating that in view of the non-commencement of the commercial business at large scale, there is no major work in the secretarial department in the present circumstances. The company is not carrying on any major business activity and there are limited revenue stream. The company has been operative and continuously struggling to manage its revenue and carry on its business activity. The operational income for the over the last 8 years has been barely able to meet ends in clearing the dues for the regular utility services and other statutory payments from the limited sources of the revenue being generated from the partially let out a space of the company property. Further, it is stated that the company is continues to battle for survival and in making all possible and reasonable efforts for generating fixed income means to stabilize the business activities of the company as well as fulfillment of the compliance in all respect. Company and the board are keen to comply the provision of Companies Act to appoint a whole-time company secretary and are making sincere attempt to fulfill this requirement on priority. Furthermore, under section 454, subsection 4 of the Act, read with the Rule 3, sub-rule 2 of the Company Adjudication of Penalties Rules 2014, notice were given an opportunity to submit a reply by issuing an adjudication notice to why the penalty should not be imposed under the provision of section 203, subsection 5 of the Act against the company and its officer in default for a stated violation. Let's see the legal provision of the law. As per section 203, subsection 1 of the Act, every company belonging to such class or classes of company as may be prescribed shall have the following whole-time key managerial personnel: MD, CEO or manager, or and in absence, a whole-time director, company secretary, and chief financial officer. Provided that an individual shall not be appointed or appointed as the chairperson of the company in pursuit of article of the company as well as the MD or CEO at any same time after the commencement of the Act, unless the article of such company provided otherwise or company does not carry out multiple businesses. Here, the legal provision is given in the adjudication order, and if any office of the whole-time key managerial person is vacated, resulting company shall be filled up by the board at a meeting of the board within a period of 6 months from the date of such vacancy. And in this case, there is a delay in the appointment of the whole-time company secretary. That's why section 203, subsection 5 of Act provided if any company makes any default in complying the provision of section 203, Such company shall be liable to a penalty of 5 lakh rupees, and every director and KMP of the company who is in default shall be liable to penalty of 50,000 rupees, and where the default is continuing one, the further penalty of 1,000 rupees for each day after first, during which such default continue but not exceeding 5 lakh rupees. In order, the applicant company and its officer who have defaulted the provision for non-appointment of the whole-time company secretary are liable for penalty under section 203, 2005 of the Act, with effect from 7th February 2021 to till date, as the last CS has vacated the office on 7th August 2020. Here penalty imposed as under for number of days is 607 days on the company, 5 lakh rupees for first default, and default continues, that is the 5 lakh rupees, total maximum penalty 5 lakh rupees, and on a director, that is 50,000 and 1,000 per day, that is the multiply by 607 days, that is the maximum penalty 5 lakh. The total penalty 10 lakh imposed, 5 lakh on the company and 5 lakh on the officer in default. And ROC's opinion, the penalty so imposed is commensurate with the aforesaid failure committed by the noticee. The noticee applicant shall pay the penalty so imposed through MCA portal only as per the rule 3 sub rule 14 of the company education of penalty rule. Appeal against this order may be filed under section 454 subsection 5 of the Act, in writing with the RD, MCA, RD. And attention is also invited regarding consequences of the non-payment of penalty within the prescribed time limit of 90 days from the date of receipt of the copy of this order. As per section 454 subsection 8, and also as per the rule 3 sub rule 3 of the company adjudication of the penalty rules as amended by the company adjudication of penalty amendment rules. Copy of this order is being sent to the company and officer or director officer who is in default. Thank you so much for watching this update.